morning.
Good morning.
So today's Monday, July 24th. Welcome to the First District Court of Appeals. We have 4 cases on the docket this morning. Only 2 are scheduled to argue by the same 2 attorneys. So the first case we have is case number C220581, with the State of Ohio versus Brown, and that has submitted on the briefs. Case number C220421, State of Ohio versus Moore, also submitted on the briefs. The third case we have, which is scheduled for argument, is case number C230016, Bethany Densler, Administrator versus Durrani et al. If you can please identify yourselves and your readiness to proceed.
Your Honor, Philip Williamson on behalf of Appellants Dr. Durrani and Cast, ready to proceed.
Good morning, judges. Robert A. Winter Jr. on behalf of appellee Bethany Densler, Administrator, and the proceed.
Thank you. And the fourth case, which is scheduled for argument, and because it's the same attorneys, you need not identify yourselves, is case number C220326, Bender versus Durrani. Attorney Williamson, if you want to step up to the podium when you're ready. Would you like to reserve time?
Yes, please, Your Honor. 3 minutes, if you don't mind.
3 minutes, okay. Whenever you're ready, you can start.
May it please the Court, Philip Williamson on behalf of Dr. Durrani and Cast. The Court, in part, decided this case on Friday when it issued its opinions in Stevenson and Hounshell, but I actually want to start with what I think is the easier solution to this case. But first, let's level set. Mr. Densler was in poor health long before he ever came to see Dr. Durrani. I'm not going to belabor the Court with a long recitation of the facts, but it's important to keep in mind this is a gentleman who had had 10 surgeries, a couple of gunshot wounds, a stab wound, at least 1 concussion, and an addiction to fentanyl and Percocet.
How does that go to the back issues and Durrani's care, and in this case, the misrepresentation, which is really what's before us?
Well, Your Honor, I think one of the lessons that the Court was trying to communicate in Stevenson and Hounshell on Friday is that there is a serious question about the potential harmfulness and prejudice of evidentiary errors when you have these close cases. Particularly in Stevenson, you have an individual who comes to Dr. Durrani in significantly poor health, undergoes surgery, and reports improvement, which is exactly what you have in this case. You have a gentleman with a long history of an assortment of ailments who comes to Dr. Durrani and sees improvement after he has surgery.
And isn't that something that the jury ultimately had to consider? Because I think he felt better for about, and if I, if there's something different, just let me know. I think he felt better for a few weeks, but there was also some testimony that there was maybe something that Durrani had shot into him during the surgery that Durrani had told him about.
Well, Your Honor, the source of his post-surgical pain here was not that. It was actually the fact that against doctor's orders, he decided to roughhouse with his teenage son in the months shortly after surgery, after being expressly told.
So are you saying that he was feeling better up to that moment?
Yes, Your Honor. So his first the first sort of return of pain is that he starts falling before New Year's Eve, which is about 2 months after his surgery. He had 4 falls that night. I'm not going to speculate as to why, but that sort of the return of pain comes when he starts falling. About 4 months after that, so now 6 months post-surgery, he decides to wrestle with his teenage son and re-injures his back, and that's when we really see kind of a serious return to maybe some of his pre-surgery injuries, or at least a general poor feeling of health. And again, these were incidents directly violating Dr. Durrani's instruction to take it easy and to take care of himself for that kind of first year after surgery. And so
but how
what
does
you
that
see
go to the misrepresentation, which is what we have in front of us?
Your Honor, like I said, that was the sort of level setting of what we have is at best a close evidentiary case. So the misrepresentation is, if you read the jury interrogatory the second time, is
Because
that...
I'm sure you don't want us to remand it for negligence.
No.
Okay.
You're right. It's that the alleged misrepresentation is telling Mr. Denzler he's going to be paralyzed or that his head's going to fall off if he doesn't undergo surgery. And that evidence comes in two spots in the trial transcript. One comes from hearsay testimony from Dr. Tayeb, which should have been rejected as hearsay. It's not habit evidence, as the court, I think, explained on Friday. And even if it counted as habit evidence, Rule 406 habit evidence is not an exception to the hearsay rule.
Which is also interesting because the jury seemed to attribute it to Denzler, did they not?
So that's the second place where that testimony arrives, which is from Mr. Denzler himself testifying almost a decade after his surgery. And on that point...
But in the record, with regard, there was two pieces. One is, as I recall, one had to do paralysis, but for the surgery, and the other one had to do with the loss of the bowel bowel control. Is that what you're referring to?
Well, so those two statements from Mr. Denzler come in kind of the same chunk of the trial record, and implicate the same problem, which is that Dr. Durrani's trial counsel tried to cross-examine Mr. Denzler on the lack of any reference to these alleged misrepresentations or statements from Dr. Durrani when he gave a trial deposition less than 2 years after surgery.
And I guess as I read through how this issue came up, it just didn't seem like it was proper impeachment. Like whoever trial counsel was didn't seem to follow like impeachment 101 and ask the witness, like, do you recall testifying this way, and present the statement in the proper manner. Is that the issue here?
Well, Your Honor, part of the problem is we don't actually know what the issue was because there's no basis given for the objection, there's no basis given for sustaining the objection, and there's no basis given for striking that question and testimony in front of the jury. So we don't actually know why it is plaintiff's counsel objected or why the trial court sustained that objection. But, Your Honor, one problem here, at least, is that trial counsel didn't really get a chance to lay the foundation for this impeachment or work up the impeachment. We are in the middle of cross-examination on Mr. Denzler's prior deposition testimony. So it's not as though this is a witness who's not been confronted with his prior statement. But he's asked the question, while you were giving that deposition, you made no reference to these statements, right? And the line of questioning is cut off there.
So would you say that my statement about impeachment 101 might be inaccurate because it's not really a prior inconsistent statement, it's just an omission that did not come up in the prior testimony?
It's an omission that we think at least one inference that a jury could reasonably draw. It's an omission that suggests this sort of 10 years later testimony about paralysis and about loss of bowel function was probably something developed later and not actually sort of part of Mr. Denzler's initial recollection of
Well, that would be your theory on it. I think your point is that it should have gone to the jury for the jury to determine.
It should have gone to the jury, and counsel should...
It might have been a prior inconsistent statement. It may not have been a prior inconsistent statement. It might have been an omission. It may not have been an omission.
And counsel should have at least had an opportunity to develop that line of questioning.
Understood.
And that's part of the reason why I spent so much time sort of walking through Mr. Denzler's sort of prior medical history, is that you have a case that rests really on these two moments in the trial, these two moments of testimony in the trial. One of them was patently inadmissible as hearsay, and the other should have been and could have been challenged.
And so I want to go back to the patent hearsay because on my review of the record, it seemed as if the discussion of losing control of the bowels was not part of Denzler's evidence or a testimony, and yet the jury attributed it to Dinsler.
Your Honor, and this sort of reiterates one of the kind of key problems we have in this case is you have two very sort of small, very discrete items of testimony supporting the entire jury verdict that when you review the trial record are suspect at best. When you have a jury that is unclear on who they actually heard testimony from, you have testimony that goes to the jury's core theory that should have been, deemed as inadmissible hearsay. It's hard to look at this trial record and say the evidentiary errors here were harmless. The evidentiary errors go to the one sentence of the jury's interrogatory where it explains its theory of the case.
Now, you also have an argument with regard to standing. Can you pivot and discuss that?
Absolutely, Your Honor, because this is the one if it were up to me, that I would prefer that the court decide first, because I think the result here is a $0 judgment.
It's in essence jurisdictional.
And that is, Your Honor, that as I think we've discussed in going on a dozen of these appeals now, the rule in Ohio is pretty straightforward. If you have an insured plaintiff and the insurer pays the entire loss, which is what you have here, then the plaintiff does not have standing to bring a claim for past medical damages.
What's interesting to me is the case that you cited. In that case, the only thing at issue was the medical damages. That was the only thing that was at issue. And so that's not where this case began. This case began, there was a theory of negligence. There was other compensatory damages that was being sought.
Well, sure, Your Honor, there were other compensatory damages being sought, but this is the only set of damages that the jury was willing to give, and the one set of damages the jury awarded also happens to be the set of damages that Mr. Dinsler did not have standing to seek in the first place.
So would you say that there was standing to seek the medical damages at the onset of the case?
No, Your Honor.
Okay, so what would be your support for that?
Your Honor.
Because I think there's two moments to look at. One is when the case was filed, because obviously if there wasn't standing there, then there wouldn't be standing now, right? And the other would be at this point in time. So if you're saying that the standing issue goes all the way back to the initial moment, to the filing of the complaint, really, then what would you use to support that?
Well, it's the fact that Mr. Dinsler never had to pay his medical bills. Medicare covered the entirety of his medical bills.
But then that goes back to my question. The case that you cite, in that case, the only thing that was at issue were the medical damages.
Right,
and so the language that you're relying on doesn't apply here because there was more than medical damages.
Well, you're referring to the punitive damages or to the fact that there are sort of other compensatory damages sought?
In that case, the only compensatory damages at issue was medical damages.
Well, Your Honor, so we will grant that Mr. Dinsler has standing, having allegedly suffered an injury, had standing to seek pain and suffering damages. If he had some out-of-pocket cost, he has standing to seek to recover those. But as to past medical damages, that is the cost of the medical treatment that he received from Dr. Durrani, he did not have standing to seek those.
Let me ask you this:
he can't recover it?
You're not suggesting that there's no way that the past medical damages could be admissible at trial, are you?
Your Honor, it is. We're not suggesting that there's no context in which the past medical damages would be admissible. What we're arguing is the much more narrow point that Mr. Dinsler was, at no point in this case was Mr. Dinsler permitted to recover past medical damages. At no point was he permitted to go to the jury and say, this surgery cost $70,000, so I should get $70,000. He did not have standing to seek those damages because he was not the real party in interest to those damages. Medicare was. And if Medicare does not attempt to either enter the case itself to recover those funds or authorize Mr. Dinsler to seek it on Medicare's behalf, he can't, and he's simply not permitted to recover those damages.
Why isn't
Because
this just a joinder issue?
Well, Your Honor, it's not just a joinder issue because it's a Rule 17 real party and interest issue. The action must be prosecuted.
But what if he, like, consider another factual scenario. The jury awards $200,000 and doesn't specify what it's awarding it for. Like, it's just a general verdict, right? And so then Medicare at some point sees that and says, whoa, you got $200,000. That includes the $60,000 that we paid you. We're going to exercise subrogation rights. Well, like, we don't know, right? We don't know whether it was or it wasn't. So how does that scenario, how would you apply your rule to that scenario?
Your Honor, this is one of the reasons why you have to pursue an action in the name of the real party and interest, is in part to avoid exactly that scenario when the real party and interest comes back and says, I see that you've received an award, pay me.
Right.
So
you're saying that by pursuing that, he's in effect opening himself up to the subrogation claim in my hypothetical?
Well, Your Honor, one problem, and one of the reasons why Mr. Denzler doesn't have standing to seek past medical damages, is that in the state of Ohio, he never would have been on the hook to his insurer.
Sure.
Which I think we discuss at some length in our brief. Mr. Denzler had no out-of-pocket costs. He never would have had out-of-pocket costs, and even having recovered the out-of-pocket costs he never paid, Medicare can't or won't come back and get that from him. At the very least, he hasn't put anything on the record to suggest otherwise. Stipulating, Your Honor, that I won't say stipulating, let's not use a legal term of art, but granted, maybe the rules operate, the sort of background rules operate differently for Medicare, given that it's a federal government agency. But again, all of these are questions that are coming up because a party who did not have standing to seek past medical damages took it to the jury anyway, and the jury, which I think the record is pretty clear, was tentative at best on a verdict in the first place.
Thank you, Mr. Williamson. Unless there's any other questions. All right. Thank you.
Thank you, Your Honor.
Morning, judges. Bob Winter on behalf of your plaintiff. One point I want to bring up before time eludes me is the judges instructing to the jury about the inference that can or might be available because of Dr. Durrani's absence. That inference is permitted under the case of Silveris versus Wrench, 22 Ohio State, 2nd at 82. I submit it's direct on point and authorizes that. And that was brought up in Honchel, and we'll take that up with the court at another matter. But you need to know that. As the court mentioned, there was no prior back surgery in Robert Denzler's remarkable history. All of these things that Dr. Durrani and Cass mentioned about the history were presented to the jury, and they sounded what they had.
Can you go to the question about whether or not defense counsel was allowed to cross-examine on those questions about what Durrani told him?
But you've got to lay a foundation, Judge Bergeron. You have to do that.
Well, but what was the basis for the trial court not allowing that?
They didn't lay a foundation. My opposing counsel at trial conducted his cross-examination of Mr. Denzler, and then at the end, oh, by the way, you didn't mention any of this stuff in your deposition, did you? That's not the way you cross-examine a witness. That's not the way you do it by extrinsic evidence.
Right, but that's generally for like an inconsistency. And I think what they're arguing, if I understand it correctly, is that there was an omission, like he did not reveal that in response to questioning. Is that any different?
No,
Okay.
because he's got to tell my colleague at the trial level, well, the transcript hadn't been made, so let me try that again. Mr. Densler, you didn't mention anything when I asked you about prior back. You didn't mention anything. You just, when I questioned you about this specific question, you didn't mention anything. Well, why is that? Or, in fact, you had a problem, and you didn't mention it. I mean, that's the kind of foundation that the authorities, we say, require. And the judge was perfectly appropriate to sustain Mr. Johnson, my colleague's question. Now, no one did anything to stop Dr. Durrani and Cass' attorney from reframing the question. They just went on to the next topic. That was their decision, not mine or my colleagues. And thus, the matter is waived. They should have, if they wanted to pursue it, they could have, they didn't. One thing I wanted to, I think this case has some parallels to the Stevenson case with Dr. Tab. At the end, Stevenson was decided to be a close case. This one's not. It's not a close case. There, at the end of the, after the surgery, Mr. Densler had 3 weeks worth of okay, and then things got really worse to the point where he had to have a revision surgery by Dr. Doss in Louisville for various problems with his back. Mr. Densler said he got worse.
Were these like post-fall, post-wrestling match with Sun? I mean, is that when the pain originated?
He went to the emergency room on several cases. One of them clearly was. Don't know the timeline.
But I mean, I think that this gets to like whether this is a close case. I mean, there are potentially intervening causes in terms of what is the root source of his pain, whether that's the malpractice, the alleged malpractice or not. And I mean, the fact that the award was only the $60,000 in past medical expenses, there was no going forward care, there was no pain and suffering, like suggests it's a pretty close case.
I would respectfully submit that the medicine is pretty clear in favor of Mr. Densler, and the revision surgery and the reasons for it enumerated by Dr. Doss make that clear. You don't get that by merely wrestling with your son.
But, I mean, this truly was a battle of the experts, right? I mean, it's Dr. Durrani had his experts, your client had his experts. It seems to me that this really was a battle of the experts, which in that case, credibility is very important.
That's right. And it was.
And Dr. Tayyeb's testimony, which this court found similar testimony to be inadmissible in Stevenson, wouldn't that have bolstered Mr. Densler's testimony?
That would, I think that Drs. Bloomfield and Sayani stood on their own without the need for Dr. Tayyeb to discuss the concept of being paralyzed or not. No one, even their experts, said that there was no risk of paralysis here, if I recall. That was just a false statement. And Taib had no input into that other than, as you've just enumerated, Judge Bach. The medicine was clear. There was going to be no paralysis. There was no need for this. Surgery, I know that they said there was, that their experts said there was. Ours was not. The jury believed ours. Did Taib play a real role in that? I think not. And I don't think it's the close case that Stevenson was. Excuse me. Let's see. Stevenson had other factors that are present here, but that it all sums up to my concept of Stevenson had 4 surgeries over many years. We had 1, and then the reversion surgery based upon the problems that Dr. Durrani created that Dr. Doss fixed. And that didn't come from a one-time slip with a wrestling match with his son. Neither did all those ER visits. 1, yeah, sure. But that's, he didn't get any better. That's the concept. And the jury wasn't swayed by the fact that there was evidence of the wrestling match. And I've already addressed the issues of past medicals in my brief. They're immune, or the Medicare's and Medicaid have sovereign immunity. In
Right, but I mean, what happens practically? He's received $62,000 or judgment for $62,000,
Yes.
but he did not pay, and that is not really damages to him. So let's say this gets affirmed and the defendant pays you $62,000. Where does that go?
It goes immediately to Medicaid. We've cited references to Title 42 of the CFR. The estate would be liable for that. My colleagues below would be liable for it if that money wasn't paid. That would be a bad thing if that money came from him to me, and I distributed it to under Ohio's.
Well, but then, like, what is Densler's role then in terms of these damages if the money doesn't even go to him? He can get no benefit from it.
We didn't know that coming in when we filed the suit, what the jury would do. I mean, we can sit here with 20/20 hindsight.
Well, right, but I mean, you don't know what the jury could do. You were hoping to get more damages, but like you knew, like you had to know at some level that he had not paid out of pocket for these medical expenses. Like you had to know that, right?
Sure, I think that the record reflects that there was a Medicaid lien that the trial court asked us to go get Medicaid into the case, and they exercised its right not to do so. The case shouldn't stall out because we don't have the power to bring them in.
Yeah, but I don't think it's like stalling out the case. I think it's just, at least it would be removing one line item of damages that you're seeking, and you would just be, I mean, if the defendants are right here, you would just be prohibited from seeking those damages that he's not incurred. You would still be free to seek all the other damages to which you'd be entitled.
Well, when Mr. Williamson writes that check to me, that check is going to Medicare. Right. Okay. It's not going to my client. But as we indicated in our brief, we have the right to pursue it, and we did. It just wasn't as good as we thought it would be. Any questions for me? I'm done with my presentation. Thank you, judges, for your time. I would ask that you affirm the judgment of the trial court.
Thank you.
Your Honors, I think 3 very quick points to make here. First, in the discussion of whether this is a close case, The jury returned a verdict finding no proximate cause that had to be sent back to resolve a discrepancy in the jury verdicts. I don't know how a case gets much closer than a jury literally not knowing what the answer is.
But that could be interpreted many different ways. Would you agree with that?
I don't know that there are many, but perhaps two at most. But Your Honor, I mean, we have here a jury interrogatory that finds no proximate cause and then and awards damages. They're sent back to say, look, you have to fix one of these two. And so at the very least, we know when the jury went back in the jury room, they were not sure that Dr. Durrani actually injured Mr. Denzler.
See, that's, well, again, not necessarily. Could be they were confused.
Sure, Your Honor, one possible option is perhaps they were confused about the jury verdict. That doesn't seem to have been an issue in a number of other cases. Juries seem to have navigated the instructions just fine. But that at least I think is an argument I get to make from the way the jury handled these instructions. I think Mr. Winter understates the wrestling match. This resulted in Mr. Denzler passing out and himself believing that he may have disrupted the hardware in his back. The second issue is that it's the Medicare question. From Mr. Denzler's brief, we may never be capable of getting Medicare to join in this action to assert its lien. We don't have anything in Mr. Winter's brief and any record citation to Medicare having or asserting a lien in this case. The only evidence that we have that a check from my client to Mr. Winters is going to go straight to Medicare is what you heard from Mr. Winter at the podium today, which is, again, why the action has to be pursued in the name of real party and interest. That's why Rule 17 exists. It's got to be followed, and it wasn't here. Last, Judge Bach, to one of your questions about credibility being key here. Well, Mr. Winter wants to lean on his other experts talking about paralysis not being a real risk of Mr. Denzler's condition. The key issue in this case was whether Dr. Durrani actually told Mr. Denzler that paralysis was a risk of his condition. And there were only two people who could speak to that, and that were Dr. Tayeb and Mr. Denzler. We have reasons to question Mr. Denzler's credibility, and Dr. Tayeb should not have been permitted to offer that testimony in the first place because it was an admissible hearsay. For these reasons, Your Honors, we respectfully request a reversal of the judgment below with instructions to enter a judgment in favor of Dr. Durrani and Cast. Barring that, we would request a new trial.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. And now we're going to move on to your second case, which is Bender v. Durrani.
And I think I'll reserve 3 minutes again for rebuttal, if you don't mind. Similar to, may it please the court, my name is Philip Williamson, again on behalf of Dr. Durrani and Cast. Similar to the case you just heard, I think it's important to do a little bit of level setting here. Because again, we're in, I think, close case territory that tracks pretty closely with Stevenson and Hounshell. This Mackenzie Bender at 10 years old is diagnosed with scoliosis with a 7-degree curvature in the spine. The doctors recommend waiting and see. 2 years later, that scoliosis has progressed to a 35-degree curvature. The doctors at that point recommend a back brace. So this is for a back brace for a 12-year-old that she would have been in for 5 to 6 years. It would have been hard, uncomfortable. So her mom decides, let's look for a different option. Go to Dr. Durrani, who recommends spine stapling surgery, and it works.
Can you back up for just a second? So the brace was working, correct?
No, Your Honor.
She had only worn it for about a month, and the curvature had reduced, correct?
Well, Your Honor, on some level, you can't force a patient into a treatment that they don't want.
I mean, isn't that, I mean, during the testimony at trial, I mean, that's what most teenagers are going to do. But the brace was working, correct?
It was, Your Honor.
Okay.
as did the surgery here. And that's I think the key, sort of the key fact to hang on to is Dr. Durrani ultimately delivered on what the patient wanted, which was to address the spine curvature, to avoid the brace, and an improvement in condition and pain.
But she didn't have pain beforehand. The brace might have caused pain, but her back, absent the brace, she did not have back pain.
Well,
correct?
Correct, Your Honor. But I mean, we're talking about a 35-degree curvature in the spine. This is going to hurt it. So this is not a situation that can continue indefinitely.
But at the time, though, at the time of surgery, I mean, you said it improved her pain, but she didn't have pain.
Well, so allow me 2 minutes, Your Honor. Post-surgery, she's reporting not having pain. And in fact, you're not seeing pain post-surgery at all. Nothing stronger than a Tylenol, which leads to the question, so how did the jury come up with $250,000 worth of past pain and suffering?
One more question before you get to that.
Sure.
You said that there was no report of pain, but she did say that she was in pain. Now, when she went to the doctor for the sniffles, as they talked about at trial, or when she went to the doctor for something completely unrelated, no, she didn't talk about her back pain then, but she did say she was continued to be in pain. And as far as the pain medication, she was allergic, or I don't know if allergic is the right word, but she had a reaction to any pain medication other than Tylenol, correct?
You're right. So one question is how broad is the menu of pain medications that we're pursuing here? But what we have is a patient who is not taking anything stronger than Tylenol. I find it a little difficult to believe that you have an allergy to literally everything pain medication under the sun, except acetaminophen.
Well, that's maybe what the jury believed.
That may be what the jury believed. But, Your Honor, we are again sort of talking about a case where we're making some fine distinctions, and at this point, perhaps doing some guessing about what the jury is thinking. And these are exactly the kinds of cases where making good evidentiary rulings is critically important. If we're in a spot of having to say, look, well, maybe the jury believed that she was allergic to all pain medications, and maybe the jury believed that the surgery was unnecessary, even though you have a patient that did not want the back brace. The more we're having to speculate on what the jury is thinking, the more important it is that the jury is presented only with competent admissible evidence and with good jury instructions. And we don't get that here. And so, Your Honor, I take your point. There is a theory of this case where Ms. Bender is at least sort of not made better off by Dr. Durrani's surgery. It's not my theory of the case, but it is one. But the fact that you and I can continue to argue about what was surgical outcome, what was sort of ordinary course of life, what was we have a 13-year-old with an interesting set of allergies, again suggests that this is not a case and this is not a punitive damages verdict that comes purely out of a good, clean, clear understanding of the medicine and the care in this case. Instead, what you have is an invitation to punish a doctor that you think is a bad person and a liar, and a court quite literally telling the jury, and if that's what you want to do, that's the inference you get to draw from his absence. An instruction that, again, on Friday this court indicated should never have been given.
What about Mr. Winter's point? I forget the case that he cited in saying that basically we were wrong in Hansel.
Your Honor, I would say, first of all, several times Mr. Winter and I have both come to this court and asked you to reverse yourself into Ronnie-related case.
I am aware.
And I would say this is perhaps not the one to begin indulging that. What Mr. Winter cited for you was a case, if I remember his citation correctly, out of the 2nd District, which is not this one. It's not a binding case here. And frankly, Your Honor, what you didn't hear was an explanation for why you were wrong on Friday.
Right, that's what I want to hear. Why are we right? Why were we right on Friday?
Well, Your Honor, one of the reasons you were right on... You're right on Friday for all the reasons that you stated. But you're exactly right to point out this instruction invites the jury to make inferences that are plainly impermissible. You can draw whatever inference you want from Dr. Durrani's absence. Well, the jury's not actually permitted to draw the inference that, he's in Pakistan because of consciousness of guilt over what may or may not have happened to Ms. Bender. Like that would have in fact been an impermissible inference. That is, number one, the inference that plaintiff's counsel certainly tried to sort of put in the jury's mind, and then one that the trial court told the jury they were fine to draw. That alone is simply improper. The jury, it was an incorrect statement of the law. Like the jury was in fact not permitted to draw whatever inference it wanted from Dr. Durrani's absence. And a legally incorrect jury instruction, really, it would be prejudicial in any case. We think it's particularly prejudicial in the facts of this case, and in, frankly,
You're saying it's
intricacies.
prejudicial in any case. I mean, it sounds like basically any appellant that, obviously things didn't go their way, otherwise they wouldn't be the appellant. If they received that jury instruction, that's reversible error.
Your Honor, to give the jury an incorrect instruction on the law is, yes, I think in the mine run of cases, that's going to be a reversible error. I think even if you don't feel comfortable with that proposition, it's certainly one here for the reasons that you stated on Friday. That at the very least, when you have a case where you've got a real question about liability, when you have some serious evidentiary errors, you couple that with a patently incorrect jury instruction.
I don't see any argument whatsoever in your brief about the jury instructions on this issue.
Your Honor, it's in Section 1, subsection D. It's in the discussion about the many ways that plaintiff's counsel sort of inflamed the passions of the jury by referring to the fact that Dr. Durrani is in Pakistan and from Pakistan and educated in Pakistan.
I know that part. I understand that you are arguing that the parties, or that Ms. Bender's counsel shouldn't have talked about his absence. I see that part, but then we argue in the almost dead center of that section that the court compounded that problem by issuing the whatever inference jury instruction. I am checking my notes on this. Now you have me worried. I mean, if I missed it, fine, but
Your Honor, I will confess some mild embarrassment that may be in Dinsler instead. At which point I'm perfectly happy to highlight, I think, the other sort of important evidentiary areas here, which, again, are all things that were covered on Friday, in Friday's opinions in Houshell and Stevenson. I think one that in nearly every appeal that this court has seen in the last 3 months is the Durrani collage, and in particular, the license revocation and other lawsuits.
I'm glad you brought that up. So with the revocation, I read the transcript pretty carefully. And in jury selection, Ms. Bender's counsel mentioned at the very beginning that his license had been revoked, and that is something in the box. Durrani's counsel mentioned it 17 separate times in jury selection. That was before any, it was mentioned in opening statement, it was mentioned in closing statement, and then in the collage. But it was mentioned 17 separate times. I guess I'm struggling to understand how we can find, and yes, the admission wasn't improper, that was already determined. But how are we to find prejudice, being that it was mentioned 17 separate times by Durrani's trial counsel?
Well, Your Honor, context is important. So this case is tried after the trial court has determined that it's going to admit the collage and admit the license revocation commentary in multiple trials. And if I remember right, this case was tried around the time this court declared that error to be harmless in Setters. And so what you have on Dr. Durrani's side is counsel recognizing, look, the license revocation evidence is coming in whether I want it to or not. Now we're in damage control. If we were in a posture where, for example, Hounsel had come out 3 years ago and the court had sort of firmly put its foot down that this is an error, it's a prejudicial error, we might have had a completely different, a completely different outcome in Bender and a completely different trial strategy. But you had counsel sort of working with the record and the law that was standing in front of it, which included a trial judge who, at various points had even himself instructed juries. And so I think that you find prejudice in that Dr. Durrani's counsel is not making the strategic decision to try to take the sting out of this evidence if we know on the front end that evidence isn't coming in. Instead, it's, well, how is our strategy impacted by the fact that we know this evidence is going to be admitted? And we know it's going to be admitted in a pretty inflammatory and prejudicial fashion coming in through this collage. And we're also sort of stuck with plaintiff's counsel saying, his license was revoked, I want you to put that in a box, which is akin to saying, look, we have a pink elephant in the corner of the courtroom. I think the most important thing here is that you do not at any point take notice of the fact that that's there.
Thank you.
Your Honor,
If you want to go ahead and wrap up unless there's any other questions.
Your Honor, this case, again, tracks pretty closely with the errors and the issues that this court identified in its decisions on Friday. You have license revocation evidence that comes in that shouldn't have and that is prejudicial for exactly the reasons the court described. You have evidence of other medical malpractice lawsuits that comes in that shouldn't have, that was prejudicial for exactly the reasons the court identified. And you have a significant jury verdict being assessed for a patient that wasn't really injured by Dr. Durrani. So for these reasons, Your Honor, we respectfully request that you vacate the judgment and remand for a new trial with the inadmissible evidence excluded this time around.
Thank you.
Judges Robert A. Winter, Jr. on behalf of Pelly Mackenzie Bender, and we're ready to proceed. Before proceeding further, I'd like to state that the trial court's instruction on inferences that may be derived from Dr. Durrani not being present, again, is found at Silvius, Silveous versus Wrench, 20 Ohio State 2nd, 82. It's in the syllabus, and of course, developed within the
What's
case.
in the syllabus? What's the rule?
When it appears a litigant knows of the existence of a material witness, and such witness is within the control of the litigant whose interest would naturally be produced to him, and without satisfactory explanation he fails to do so, the jury may draw an inference that the testimony would not be favored to him is error, where the jury is not also instructed regarding the facts to be considered in determining what evidence a litigant will naturally be expected to produce at trial. The first part of that syllabus deals with an old case from the Ohio Supreme Court about the missing witness rule, and the second point is it's got to matter. And we will respectfully contend and will show that Dr. Durrani falls within the missing witness rule, and the trial court discussed the facts to be determined and what evidence Dr. Durrani would be naturally state at trial. And we'll develop that for you when we get the chance.
Can I focus you in on something?
I'm sorry.
May I focus you in on something, please? So this court has already determined that evidence of the license revocation and evidence of the prior lawsuit, I believe it's ruled that, were improper, correct? In Stevenson?
I did my best to persuade you otherwise, but yes.
Okay, so in this case, this particular case, Ms. Bender, tell me why this wasn't a close case, considering that Ms. Bender had been cleared for all athletics. Ms. Bender ran track. Ms. Bender went snowboarding a couple of months before the trial. I need for you to convince me that this was not a close case.
Sure.
Where this evidence did not matter.
She was doing pretty good with a brace, okay? And the surgery was not needed.
But what, even if it wasn't needed, let's say that it wasn't needed, what are her damages?
She has right-sided staples along her spine from T5-6 to T11-12. The S-shaped scoliosis was in fact substantiated, but she will also have surgery in the future. Dr. Her pediatric orthopedic surgeon stated that she will need surgery.
Surgery for what? I mean, I guess kind of building off of Judge Bach's questions, like, you've got someone who, by all accounts, seems to be doing physically fine. This isn't a situation like a number of these plaintiffs where they keep going back and seeking more treatment because they're having all these problems. And I mean, I've run my whole life and I've run with back pain. It's really hard to do, you know? And, and so, like, the fact that she's able to do all this, which is fantastic, but it's also a question of, like, how did she get damages here if it weren't somehow infected by the inadmissible testimony?
The inadmissible testimony, Dr. Durrani's surgery aggravated Ms. Bender's pre-existing scoliosis, and he made the condition worse, not better. That's at page 891 of the transcript. They're permanent. That's at page 891 to 892 and 894. Third, Ms. Bender will require spinal fusion from T4 or T5 to L1, L2 in the future due to the documented progression of the scoliosis. That's at page 882 to 884. She was damaged, and the jury believed that. And they awarded future medicals, I believe.
Yeah, I mean, they awarded $10,000. I mean, that's not enough to cover.
Well, I was going to say, it's not what I would have awarded, but...
Well, but I think that, again, it's hard for me to look at a $10,000 award as the jury embracing the notion that she's going to need future surgery, and that future surgery is an approximate cause of
then the award
malpractice.
should have been zero.
I mean, but your witness, I think, testified that the surgery would cost between $150,000 and $200,000.
It did. Yes, he did.
Yeah.
That's exactly right.
Okay.
The jury must have slipped up when filling out the form, Judge. But to get to Judge Bach's point, the past lawsuits, the past some of the offensive stuff in the collage didn't impact the medicine that Dr. Mortimer testified to. And one point I've taken it aside, there's a lot of discussion about Pakistan. Well, Dr. Durrani was listed as an expert in their pretrial disclosures. And, when I'm taking a doctor's deposition, question 2 is, and where are you from? And where did you go to school? And where did you work? And where did you do your residency and internships? In this case, per the collage, all of those were Pakistani locations. Now, I understand.
Yeah, but
I
I mean, I hear you on that, but there's a difference between saying, where did you get your medical degree? Oh, I got it in Pakistan, versus using Pakistan to almost invite the jury to hold that against him because of where he's from. And I feel like that error is not presented well in these appeals that we've had, but it looks to me like that's what's going on in the opening and closing statements, because there's no need to go into Pakistan. If he was from Alabama, you wouldn't be talking about that.
I think I mentioned Pittsburgh the last time I was judge. There was no objection.
Yeah, right. No, I get it.
When I hear what you said in
But
Stevens.
yeah, and I think that in Stevenson, we see all of these issues that should not speak to the question of whether there was malpractice here. And it's hard to look at those and say they didn't impact the jury. I mean, you're trying to try him as if he's a bad guy, and maybe he is, but I mean, it's just like in criminal cases. Like, we don't give carte blanche to do character assassination of even people who've committed heinous offenses, because due process requires that they be given a fair trial.
The jury found that the negligence was he Pakistani or where he went to school. The negligence was found on the medicine. A reasonable and prudent spine surgeon would not have performed surgery on Mackenzie Bender at this time. That's all I can say.
Basically, what you're saying is that there's evidence to support the jury's outcome.
Yes. I've done my best to brief it in the brief. And I would ask that this court affirm the judgment of the trial court. Thank you very much, judges.
Your Honors, I want to start with a question or a point that Judge Bergeron made about the future medical damages in this case, which is that plaintiff's expert testified that future surgery would cost somewhere between $150,000 and $200,000. The jury awarded a $10,000 future damages verdict instead, which strongly suggests the jury did not think that Ms. Bender would need surgery in the future, which again goes to, I think, a point that Judge Bergeron was starting to make, that this does not seem like a case where the jury concluded Dr. Durrani caused Ms. Bender any kind of serious or long-term harm. And when asked, what you heard from opposing counsel was not like a description of long-term harm. What you heard was basically a description of the surgery. There are staples in her spine. Well, of course, that was the surgery, but that doesn't answer the question. And those staples are causing what damages? What will be necessary in the future to solve them? The jury certainly did not seem to think it would be much. And so what you have here is a case where, in my view, and I think as our sort of side of the evidence ledger suggests, a plaintiff who wasn't injured, but at the very least, a plaintiff who's not injured much. I think that much is at least undisputed from the trial evidence.
So what you're arguing, basically, if I'm understanding you correct, it really doesn't matter if, for example, the jury found that the surgery wasn't necessary, that shouldn't have impacted the verdict because she didn't have any long-term lasting damages. Is that right?
Well, part of what I'm
Even
arguing.
if. It was an even if.
Correct, Your Honor.
Okay.
But I think actually our core point here is this is a case where the evidentiary errors really may have had an impact on the ultimate jury finding in this case. This is one of those cases where, unlike Setters, I don't think these evidentiary errors can be deemed harmless.
In Setters, the collage was not played, correct?
My recollection is that the collage was played in Setters, but the way that the argument got framed for the court was really keying in on license revocation as the core problem. This case was tried before this court's decision in Setters, so before the court actually said that the license revocation evidence was inadmissible, and it was tried sort of after a number of cases already gone to trial where this evidence has come in. That's the principal reason why you see Dr. Durrani's counsel sort of trying to take the sting out of that evidence, trying to do prejudice control rather than create prejudice and bringing that up in voir dire. We have a number of other issues that are raised in the brief. I want to make sure those don't get lost, though I know the court has read them. If the court has any questions on those issues.
We're very familiar with all of these. Thank you.
Well, going back to the last point that you were making, couldn't it be said that the jury simply found the surgery to be unnecessary and the award was simply based on that determination?
Your Honor, that's not a point I'm willing to concede. Just
I think
imagine.
you've answered the question with the way you've answered. And I think that's the troubling thing about these cases is, we're not supposed to put ourselves into the shoes of the jury and figure out what they, determine at every single level. Because also the reality is, even if it was a close call, I think we would all agree that there was evidence on both sides, not just on your side.
Right, Your Honor. And our argument is not that we are not asking you to remand for an entry of judgment in favor of Dr. Durrani in this case, though I did ask for that in Dinsler. We are suggesting that, sure, there might be evidence to support the jury's verdict here, but it's not overwhelming evidence, which is what you asked for in Setters. And you have some really serious evidentiary problems that cast some legitimate doubt on the jury verdict. And that's what we have to show, to show that there was prejudice and an entitlement to a new trial.
So you're saying there needs to be overwhelming evidence in order to overcome the issue?
Well, Your Honor, in Setters, this court sort of looked at the license revocation by itself and said it was a legal error, it was an abuse of discretion to admit it, but that the error was harmless because the court was convinced that there was sort of very clear evidence of liability supporting the jury's verdict. In that case,
But that doesn't mean that the negative then becomes true.
Well, Your Honor, I'm boxing against your language in Setters. And
Okay.
The court's rationale for holding the license revocation evidence harmless in Setters just isn't present here. You don't have that sort of strong, clear evidence of liability that you're relying on in Setters in this case. You have some fairly good evidence that Dr. Durrani made his patient better off, at the very least didn't hurt her, and you have a jury verdict that is much smaller than the one that was issued in Setters that also suggests the jury was not terribly convinced that Dr. Durrani made his patient worse off. And so this seems to be a case where hearing that Dr. Durrani is a liar and a bad guy and a bad physician seems to have done some real work in the jury's mind. You couple that with counsel repeatedly harping on him, being from, educated in Pakistan. And Judge Bergeron, to your point, there is a difference between, where did you go to law school? Well, I went to law school in the United States or in Virginia, and answering, I got my law degree from the University of Virginia. There's a difference between, where did you go to medical school? I got my medical degree from the University of Islamabad, and he's in Pakistan, he's from Pakistan, he was educated in Pakistan, and your verdict needs to send a message all the way back to Pakistan. Those are simply not the same sorts of questions or statements. And so you take all of that together. I have trouble looking at this record and saying, yes, Dr. Durrani received a fair trial and a verdict decided purely on the merits of the medicine and the practice here. And for that reason, we ask you to vacate the judgment and remand it for a new trial, obviously with instructions on how to handle some of these evidentiary questions. If there are no further questions, I will take my seat. Thank you, Your Honors.
Thank you. Thank you both for your arguments this morning. I will also take this case under consideration and issue a timely decision, and we wish you both a wonderful afternoon. And that wraps up for today.